Okay, perfect. All right, so thank you for joining. Today we're going to be going over how to comply with eviction protections in Mountain View for our rent stabilized rental units. And this is going to be focused towards landlords, property owners, and managers, and sort of what you need to do um, in the whole process for eviction protections. All right, so let's go ahead and get started. All right, and just as a reminder, I will not be able to give any kind of legal advice today during this meeting. As staff, we don't give legal advice, but we do offer, information, best practices of, our local and state laws. And then just sort of as a high level overview of the CSFRA, which is the Community Stabilization and Fair Rent Act, and that sort of governs our apartment rent stabilization. And then we also have the MHRSO, which is the Mobile Home Rent Stabilization Ordinance, which governs our mobile homes and mobile home spaces. Um, so their sort of main goal is to reduce turning housing turnover in certain types of covered properties. And so it does that in three main ways. First is by stabilizing the rents, second by providing eviction protections, and then lastly for our property owners, ensuring a fair rate of return on their rental property. And just for background for our apartments in Mountain View, most of those are going to be covered by the CSFRA. And that's because the CSFRA went into effect on December 23rd, 2016. And most of the properties in Mountain View are older than that. So there's two different types of coverage for the city. We have fully covered and partially covered units. Fully covered is where both rent stabilization, your sort of rent increase limits apply, and also the eviction protections apply. And those are going to be for properties built before 1995, which is still going to be the majority of the properties in Mountain View. And then we have partially covered units that were built after 1995, where it's only the eviction protections part applies. So for the focus of this workshop today, since we are talking about eviction protections, it's going to be both fully and partially covered. So if you're covered at all, if your property is older than 2017, this applies to you. And then really briefly, we'll look at mobile homes. I don't know if we have anybody here that is a mobile home landlord or manager, but if you are, um, it's similar, but it's a little bit different. So there's two different types of kind of coverage for mobile home owners. Um, we have those people who own their actual mobile home and then they rent the space out from the mobile home park owner. So they're just renting the space. And then we have mobile home renters who are actually renting out the home, the actual mobile home, which includes sort of all that everything. So it includes the space, it includes the communal facilities, and other housing services, and they're renting that out from the mobile home landlord who owns the home. And so I don't know if there's any questions yet, but we will kind of stop periodically throughout the presentation. And if you're joining us online, you can just raise your hand, or if you want to type your question in the chat, that's fine. I like to keep sort of all of my workshops pretty casual. So if something comes up and you have a question about it, just throw your hand up or put it in the chat, and we can kind of take a second to go over that. All right, now we're just going to look at eviction protections in general. So for mobile homes, I'll stop on this one just briefly because this is going to apply to those people who are owning their own mobile homes and they're just renting the space. So generally speaking, you are going to not be covered by our local ordinance. You're going to be covered by the state law, the mobile home residency law, and that has its own set of um, just cause eviction protection reasons. So they're a little bit different than our apartment rentals or for those people who are actually renting the mobile home um, structure. So if you're owning your own mobile home, then these would be your causes, sort of failure to pay rent, violating the park rules, annoyance, non-compliance with state laws, if the park is condemned or, if there was a change of use in the park. We're not going to go into that too much. We're really going to focus on our apartments and mobile home renters who are renting the whole home. So in those cases, we have our 9 just cause eviction reasons. So we kind of like to break these up into 2 categories just to make them easier to digest. We have our tenant caused reasons, and then we have what we like to call our landlord caused reasons, or really like things that, the tenant didn't do any action to get themselves uh, terminated from their rental property. So no fault of the tenant. So for our tenant caused reasons, we have failure to pay rent, which is obviously going to be sort of the main reason that we see termination notices coming through if people miss their rent payments at the beginning of the month. And then we also have breach of lease. We have a nuisance, criminal activity, or failure to give access to the landlord when the landlord has given proper notice, right? And so for these 4 at the bottom, breach of lease, nuisance, criminal activity, and failure to give access, you as the landlord are required first to give the tenants a notice to cease before you actually issue a termination notice. And we'll get into the details of the notice to cease in a second. And then for our landlord cause reasons, we have these 4 reasons here. Repairs to the property that are going to cause the tenant to have to temporarily vacate their unit for a period longer than 30 days. So if they have to be out for over 30 days, you can give them a termination notice. If it's going to be something less than 30 days, the tenant is not going to be terminated from their unit. Um, they may have to stay elsewhere, if the unit is not habitable. However, you as a landlord would not be able to charge them rent for those days that they're not able to occupy their space, right? So you kind of would figure out your per diem and, usually you could deduct that from the rent owed at the end of the month. But if it's going to be something over 30 days, then that would sort of kick into one of these termination reasons. All right, so the other kind of I would say common one would be owner move-in. So if an immediate owner of the property and that has at least 50% ownership of the property or their immediate relative. So that's like a spouse, your parent, a sibling, or a child, right? So if those people are going to move into the unit, then you would be able to terminate a tenant. There are some specifics around that. So if you're planning to do that, I suggest coming to talk to us first. We have withdrawing the unit from the rental market, and that would be all units off the market of a property, not just 1 or 2. And then there's cases where demolition may be required, especially with habitability issues. So if any of these reasons, these landlord kind of caused reasons come up on your property, it is going to trigger tenant relocation assistance, where if a tenant income qualifies, they would be eligible to get monetary benefit from you, the landlord. You would have to pay the tenant. This is a process that the city helps and guides you through. So you're not alone in that, but just so you're aware that that does happen. Any questions on that? All right, I'll keep going. One thing that I really like to highlight for everybody is that ending of a lease is not a reason that a tenant can be terminated from their unit or evicted from the property. So, as we just mentioned, there are only these 9 allowed reasons. And as you can see, a lease ending or a tenant not signing a renewal agreement is not one of those allowed reasons. So if a tenant does not want to sign a new lease agreement or if their lease is coming to an end, what happens is that lease is just automatically going to roll over into a month-to-month lease. And so it's not an allowed reason to terminate them. All right, and under the local CSFRA, the rent stabilization law, we have specific noticing requirements that go along with any sort of termination notice that you're going to give. All right, and some of this I went over, but I'll just go over it again in a little bit more detail. But the first one that I want to talk about is the notice to cease, right? So that's sort of like a warning to the tenant, letting them know, for example, hey, you're doing X, Y, Z, that is a breach of your lease. You need to stop that behavior. Otherwise, you will receive a termination notice. So you are required to give a notice to cease for certain types of termination notices. Um, and you want to be very kind of specific in what you write in the notice. The more specifics, the better, the more information, the better. And then you also need to provide our rent stabilization division contact information so the tenant can get help if they need help. The next thing, so, say you gave a notice to cease and the behavior continues, and now it's time to give an actual termination notice. There's different amounts of time, um, depending on how long the tenant's been there and what the reason is for. So it could be a 3-day notice, and that's very specific only for failure to pay rent. So if a tenant does not pay their rent, you would give them a 3-day notice to pay rent or quit, which I'm sure most of you are aware of. And then for other types of reasons, it's going to be either a 30-day notice or a 60-day notice. So it's 30 days if the tenant has occupied the rental unit for less than a year, and then it's 60 days if they rented it for over a year. So, for example, if you're going to do like an owner move-in and you had a tenant who's been there for 2 years, you're going to give them 60-day notice for move-out. All right, the other thing to be aware of is you are required to give a copy of the notice you served on your tenant to the city within 3 days of serving that on the tenant. And so the easiest way to do that is through the online portal, but you can, hand deliver it, you can mail it to us. It just has to get to us. Um, And then if they are eligible for tenant relocation assistance, it needs to be explained there also. And then specifically for when we are withdrawing rental units from the market, and that's going to typically be for when a property is being redeveloped. Not always, but usually that's when you use that. You first need to give the tenant sort of a notice of intent. You have to let them know the property is being developed, what the timeline is going to be, when they can expect the termination notice. And then with that, a state law kicks in where those tenants get a 120-day notice period, or if they are senior or disabled, they can be eligible for 1 whole year notice. So it's kind of a lot of different timelines to keep in mind, but this is just a quick overview summary of that. So we did already talk about the notice to cease, but to kind of get into the details of what you should include, you want to do any information that's necessary to the tenant to let them know sort of what the violation is that they've done. And so when I mean specific, I mean like really specific, like date, time, place, and any other circumstances concerning the issue. For example, I've seen people do like nuisance, on October 1st, 2025 at 10 p.m. So and so was seen, smoking too close to the building that's against, the city code, blah, 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 blah. Um, so it can be that specific. And it could be they did it on October 1st, then they did it on the 15th, things like that. Just so it's really clear to them what they're doing wrong. Also included in the notice would be a reasonable period to allow them to come into compliance, and that is not defined. So reasonable could be dependent on the type of situation. So if it's, my example, like smoking in their unit or wherever they're not supposed to be smoking, it could be like, don't do it again, because then that would be violating it, right? But that's not like within 30 days. That just makes um oh, I think I might have a question. But that's a time limit. But it could also be like you have clutter on your balcony and that's against your lease or something like that. You need to clean it within 30 days, right? So it's very dependent on the issue. It just needs to be something that can hold up if you're going in front of a judge, right? So if you sort of have your own legal counsel, you can run it by them as well. The other thing that needs to be included in your notice to cease is information for the tenant's right to request reasonable accommodations. So that could be like a therapy dog or, cat or pet or something that they have a doctor, like the doctor's note and all the documentation for. And then also, as I mentioned earlier, contact information for rent stabilization division. Okay, so I'll pause there. So I think I got two questions in. Yeah, perfect place to pause. Okay, question. How do we proceed if the resident keeps violating the lease every 3 or so months? It's the same issue like smoking in the unit or like parties, loud noises. Yeah, perfect. They stop for a month or two and then repeat the same violations when they are in the clear. Yeah, so like I was kind of saying with the smoking example, um, you want to give the notice to cease. You want to be specific about when it's happening, what exactly it is, and the next time that they do it, then they're violating the same part of the lease. So that's when you would give your termination notice. So it doesn't have to be like you can't smoke for 6 months and then they wait for 6 months and then they smoke again. No, it's you are not allowed to smoke. You're in violation of this section of your lease that says no smoking indoors or whatever it is, right? You can quote it from your lease language. Um, you're not able to do that again, or you'll get the termination notice, and then you would give them the notice of termination. I hope that makes sense. So in those cases, it's not tied to a specific timeline, it's more tied to the action. So yeah, if they did it again, then you would give them a termination notice where, yeah, perfect. Okay, thank you. So then you would give them a termination notice where you want to be, again, very specific on the reason. So of those 9 allowed reasons, you want to list, I mean, pretty clearly, kind of like up near the top, what they're doing. So in that example we were just talking about, it would be breach of lease, right? Or nuisance. So you want to list off the reason that they're receiving the termination notice. It should also state that the unit is covered by the CSFRA or the MHRSO if it's a mobile home. And again, it should include the contact information for the division. Yeah, okay. So also, I think we mentioned this already, but I'll just go over it again. So if it's for failure to pay rent, that one's a little bit different because you don't have to give the notice to cease and you just do that 3-day notice to pay rent or quit instead. All right. And then I do want to make it super clear because this sometimes trips up landlords and managers who aren't aware that they need to file a copy of their notices with the city. So if you give a notice to cease or if you give a termination notice, you want to submit a copy of that to the city within 3 days. If you are registered on our online portal at mvrent.mountainview.gov, it's super easy to upload it there. You just sort of go down to your property address, and there's a three-dot action item next to each unit number. You click on that, and then it will say submit termination notice, and you just upload a copy of it. And then you have for your records the exact date, the exact time, the exact notice when you did it. So if this ends up moving forward to go to court for an actual eviction or an unlawful detainer, you'll have total proof that yes, I followed all the rules and all the regulations for the city of Mountain View. Because if you forget to do this, then the tenant can use that in court as a defense against your um, eviction case. And I have seen it where then landlords need to start all the way over from the beginning. And either the tenant stays in the unit or it just takes much longer because you're starting all the way over and potentially costing you more money. So you want to be sure that you're following all the required steps. If you're not registered, you definitely need to be registered. So please contact me and we can help you get registered. That's also a requirement. Okay, so sort of just things to keep in mind. So if you're a landlord or if you're a manager on behalf of a landlord thinking about issuing a termination notice to your tenants, definitely recommend you to contact our office first, especially if it's something you've not done often. And I see that a lot with kind of our smaller landlords. They don't do it very often. So it's helpful to just have someone kind of walk you through what the steps are. Um, and then we can kind of give you a play-by-play of all the requirements. The other thing that we can do is really connect you with our mediation services if it's something that a neighbor to neighbor issue, if they're arguing over something, which we've seen before. Sometimes we can help resolve the issue without court and kind of maintain all the relationships in the property, which can be really nice. Um, the other thing we can do again, like I just mentioned, is help you file any of those required notices with the city on your online portal. All right, any kind of questions about that in general? Termination notices, notices to cease. I'm going to keep going, but yeah, feel free just to kind of pop your questions in whenever you have them. And I think just as important as what evictions are allowed, we talk about what are not allowed. And this is going to be state law here. So, again, there are certain reasons for um, terminating the tenant that are now not going to be allowed. Um, because we have rent stabilization. So we have our 9 allowed just cause reasons. So that means If there's no cause, that's not allowed. So it used to be that you could just give somebody like a 60-day notice, or a 30-day notice, depending how long they've lived there, to move out, especially like if they're on month to month. You could just say, hey, you have to move out in 2 months, and you didn't have to say a reason why. That's not allowed anymore. And then I already mentioned ending of a lease is not allowed. So again, that just rolls over month to month. If you sell your property or you transfer the ownership of your property, that is not a reason that you can ask your tenants to leave. Those tenants are going to just roll right over with their current lease and their current rent and everything to the new owner. You are required to notice your tenants that there is a new owner. The new owner should do that, and they should also include where the tenant should now pay the rent, if they want to get those rent checks. Um, the other thing that may pop up for some people is there are regulations that allow certain types of roommates to join your tenant's lease. So they can do one-for-one replacements and they can add in certain allowed immediate family members. So if they're doing that and they're following the regulations and they're following the rules, then that, you're not allowed to uh, give them a termination notice because they have those additional people now living in there who like may or may not be on the original lease document. It doesn't happen as often as you think, so you may not see that for a while, but if you do see it, we can kind of help you again, walk you through it. The other thing, and I apologize, this is state law. The other was local law. This is state law, so no constructive evictions are allowed. And what that means, is for the landlord to do some kind of action to the tenant's unit, which makes the tenant not be able to enter the unit, makes the unit super uninhabitable so that it's not safe for the tenant to live there. As a landlord, you are always going to be required to keep your unit safe and habitable for the tenant. The only way you can legally evict a tenant is going through the courts, right? So changing of locks, cutting off utilities, harassing people so they don't feel safe, um, preventing people from entering the unit, or having unaddressed habitability issues, those are not allowed. If you saw in the newspaper, like, I don't know, 4 years ago or something, there was a story that a landlord had actually hired some people to try to physically block out a unit tenants from entering their unit, and obviously that's super illegal, and it ended up in the newspaper. So let's avoid that at all costs. Ay. All right, so again, as I mentioned, the only way to legally get rid of a tenant is to go through the courts. So that's the eviction process. And so here's kind of like a flow chart. And hopefully you can see my cursor on the screen. But what I didn't put over here, in some cases, there might be a notice to cease that happens first, right? So let's pretend it's like a breach of lease that we're working with here. So you would have given a notice to cease first. For the smoking, for example, let's stick with this example. And then the tenant smoked again in their unit where they're not allowed. So then you give an actual termination notice. And again, it's going to be super specific. It's going to say, because of breach of lease, XYZ, that's what you did. So you give them the termination notice, and then we'll say they didn't move out on their own within the allotted amount of time, when they were required to move out. So, of course, if they move out, then no need to worry. You just move on and re-rent the unit, do your thing. But if the tenant stays in the unit, they don't move out, now you have to go to court, because now the tenant is not staying in that unit lawfully. So you fill out your court paperwork, your summons and your complaint, your eviction, also called unlawful detainer because they are detaining that unit unlawfully. So you're going to court for that. And then there's kind of two paths that can happen. The tenant has a legal right to file an answer with the court if they want to go in front of a judge and plead their case. So that's the top route that we see. The bottom route that we see is if a tenant decides that they don't want to answer the complaint filed against them, and then it's going to go to a default judgment in front of just in front of the judge. The judge is just going to make a decision. There's going to be no case, there's no trial, sorry, no trial where the landlord and the tenant have the opportunity to present evidence. The judge is just going to make a determination, and that's going to result in the tenant being evicted. So this is sort of a quick path to the tenant being evicted by the sheriff. But in the case where the tenant does file an answer, they will get a trial date and they will have the opportunity to go in front of the judge and present a case. And a lot of the times, well, one reason why I said it was super important for landlords, for example, to submit a copy of their termination notice with us is because if they didn't do that step, the tenant's going to use that in the trial as a reason against the eviction. They're saying they didn't follow the rules, it wasn't done lawfully, this shouldn't be thrown out, right? And in that case, maybe the tenant gets to stay in their unit. And however, if the landlord did do all the steps correctly and they did follow all the rules and regulations, the tenant may lose that court case and then they would get the eviction granted, and a sheriff would then come out and kind of post everything on the door, letting the tenant know that they do have to, in fact, move out of the unit. And then, kind of worst case scenario is if a sheriff has to escort people out. Um, but that's sort of like a high level overview of the process. And again, I know you know, but I'm just going to say it again that that is the only legal way to get a tenant evicted from their unit. I don't see any questions. Let me just check. All good? Okay. So I'm gonna go over some new state laws really quickly. They're not really having to do with um, evictions, but I just think it's kind of a good thing to throw into the workshops because these laws are changing all the time. Um, and here's an easy place to kind of find them. So something that has it's kind of old news now, I guess, is the security deposit limit to 1 month. In pretty much most cases, unless both one and two apply to you, then you can charge up to 2 months. So if you are a landlord who is a natural person and owns no more than two residential properties with four or fewer units, you can charge 2 months of rent for your deposit. Otherwise, it's limited to 1 month. So that's kind of old news now, but the next one is AB 2801. And this is just good practice anyway, but now it's written into law. So at the start of your tenancy at the start of a new tenancy, as the landlord, you must take pictures of your unit and the condition of your unit. So that way there is a visual record of the condition that the tenant is moving into. And then also along with that, at move out, you also want to take photos of the condition of the unit at move out. And that will just be helpful for you as a landlord when you're going through and writing up sort of the deductions for the security deposit. You'll have that kind of visual proof as well. So this AB 2347 does pertain to evictions. So this one is relevant to the workshop. It extends the deadline for tenants to file an answer to the unlawful detainer or that eviction process that we just talked about to 10 court days instead of 5 court days. And that went into effect the beginning of the year. Excuse me 1 second. All right, and we're just going to continue with a couple new state laws. So there is a new law also in January about rent reporting that landlords have to offer tenants the option to report their rent payments to a credit bureau. And as a landlord, you can charge the tenant the actual cost that it costs you to report that payment um, up to $10. So you can't exceed a $10 charge to the tenant. We did consider this for rent rent controlled units, rent stabilized units in Mountain View. If the tenant decides to opt into this rent reporting, it's not going to be considered a rent increase. So it is going to be allowed. You can do it. You can follow this state law without it sort of affecting your compliance with our local law. So that's just good to know. We have another Senate Bill 611 that bans junk fees that are fees that are sort of unrelated to rent. So charges for people providing their rent with personal checks or any kind of like any kind of additional fees that don't really go along with your rent in that way are not allowed. There's another domestic violence protection that passed earlier this year. If you're a landlord and the tenant lets you know that they are a victim of domestic violence, you must change the locks for the tenant at your expense within 24 hours. And then I just wanted to highlight this one at the bottom. You'll see it in blue because that's coming up in January, which wildly is only like a month and a half away. Somehow it is already the end of the year. But in January, landlords will be required to provide a refrigerator and stove in all their new leases. There were instances where, sometimes you would have to bring in your own refrigerator, but now a landlord is required to provide that in their new rentals. All right, so some key takeaways just before we kind of wrap up for the afternoon. Um, Tenants can only be evicted for those 9 just cause reasons that we talked about. And again, you must be very specific in your notice to cease and very specific in your termination notice which of those 9 reasons you are using. So you must lay that out very clearly in your notice. Number 2, there is no such thing now as a no cause eviction. They are not allowed. So you have to use one of those 9 reasons. End of leases is not a reason that a tenant can be terminated from their unit. If the lease ends, it rolls over month to month. Right, number 4, the landlord must notify tenants in writing of the reason for eviction. Again, termination notices, notice to ceases, obviously those are going to be in writing. Just as sort of a general rule, it is not a bad idea to do a lot of your communication in writing just so you can keep a record of sort of what's going on between you and your tenant. And then again, as I mentioned, definitely contact our office if you are thinking about giving a termination notice because we can help kind of like walk you through all these steps, making sure that you are using one of the allowed 9 reasons, making sure that you're submitting to our office within the allowed amount of time. So we can kind of help you through that. We do have specific hours set aside for walk-ins. We have a housing help center every Thursday dedicated to our landlords from 1 to 3 p.m. It is virtual and in person. So you can come to our office. We're at 298 Escuela Avenue. We're that little house right next door to the senior center. If you've been in Mountain View a long time, we used to be the old teen center before they built the new one across the street. Otherwise, you can join us online at mountainview.gov/housing help clinics. And we're there every Thursday for you. All right, I know that We are kind of keeping it rolling, but if you have any questions, go ahead and type them in. We just have a few more slides. So we'll go over some resources before we're calling it for the day. I did mention mediation earlier in this presentation, but I can't really stress enough how wonderful the Mountain View Mediation Program is. They just celebrated, I think, was it 40 years of mediation? It's totally free for anybody who's living or if you're owning a property or owning a business or anything like that in Mountain View. 50 years, yes, 50 years of mediation. Thank you, Anki. It's totally free, it's confidential, and it's really successful. We have trained volunteer mediators who are super passionate about resolving conflict. It works very well for tenant landlord issues, very well for neighbor to neighbor issues. So I really can't recommend it enough. As I mentioned, also, staff is not able to give any sort of legal advice, but if you are needing legal advice, you can go to the Santa Clara County Bar Association Lawyer Referral Service, and their phone number and website are here. Or you can go to the Superior Court Self-Help Center if you're interested in looking for legal counsel. And I did also want to let you all know what other types of workshops we have coming up. On December 11th, we have a landlord focused workshop about submitting utility adjustment petitions. So if you are a smaller landlord and you are sort of in the middle of going through your utility petition to incorporate your utility into your rent, we are having a workshop on that because that deadline is fast approaching by the end of the year. And then we are also simultaneously kind of kicking off our annual registration time. So we're starting that workshop in December 16th, and it will be running through January and through February. We have many different dates that you can join us, or if you want to just come to our office and get assistance with your registration and fee payment, that will be starting soon. Right, and then I'll end here on this page for you all. This has on the left-hand side our office's contact information, um, phone number, email address. We have a ton of information on our website that we update regularly. So be sure to kind of go there as often as needed. And then you can also come to our office, again, 298 Escuela. And then our Housing Help Center every Thursday. Be sure to come and see us there. We're always available to help. And so I'll just leave this up, but that's the end of the presentation. So thank you so much for coming. If you have any questions, I'll kind of hang around. You can either raise your hand or type your question in the chat. If not, have a great day. We will be sending out a copy of this through email. So you'll get a PDF of the workshop through email so you can reference it in the future. And we'll also be sending out a link to a survey so you can kind of let us know how we did. If there's any topics you want to hear about in the future, we always love to kind of incorporate what the community wants to hear about in our workshop schedule. All right, so thank you. I do see a hand. Sybil, I think you can unmute.
Hello?
Yep,
Oh, you could hear me?
I can.
Oh, awesome. I didn't know how to use this. This is my first time on here.
Oh,
Yeah.
awesome.
Yeah. So there was something about the disability thing. You were talking about if someone's disabled. how long do you have to give them a notice or something like that? You were talking about earlier, and it just kind of went really fast. I didn't hear that whole thing about the disability because I know for the if someone stays in a property for over a year, you give them a 2 months notice, and it has to have some kind of cause because if not, you have to pay for them to relocate or something like that.
Well, there's different time frames for the termination notice depending how long the tenants lived in the unit. So if you've had a tenant there less than 1 year, you give them a 30-day notice of termination. And then if they've been living in there for over a year, then you give them a 60-day notice of termination.
Uh-huh.
But what I was talking about with the request for a reasonable accommodation is in the notice to cease,
Uh-huh.
where there's certain information points that need to be included in the actual notice itself. So you'll see on the screen here, you want to again be super specific about what the violation was, give them that reasonable period to correct that violation. And then here you give information on their right to request reasonable accommodation. And I was just making an example, like if they had an animal in their unit that you weren't aware of, but
Hmm.
it may be a service animal and they need to request that reasonable accommodation from you as the landlord. They would know how to do that because there would be that
Hmm.
information in that notice to cease.
Okay. But what
Yeah.
about the one But what about the one for, like you said, if they're handicapped? Not talking about animals, but like you're talking about if they're physically handicapped, is there certain thing I supposed to do in order, like say you have a tenant that's smoking in the unit, right? And
Mm-hmm.
they're smoking like marijuana, right?
Mm-hmm.
There's supposed to be no smoking in the property, and then they're saying they're
Mm-hmm.
not smoking, but they are, right?
Mm-hmm.
So, and they're considered handicapped, mentally handicapped. Is there some kind of clause with that in order to evict someone out, is there certain different way other than the regular way of evictions, other than C's? Is there something like you give them like a C's notice first, and then for them smoking in, even though they're denying it?
No, so you would want to use the same process. You would want to use the notice to cease where you write out, very clearly, that they're smoking
Unit.
in the unit. And then it would be the same process that we kind of went through after that, which is the
Yeah, I got that.
termination notice. And then if they don't leave from there, then it's the court process that we went through. So it's the same process.
And by law, do we have to use the mediation, or could we just go straight forward once we do all our paperwork doing the C's of notice? We don't have to go through mediation, do we?
You don't have to, it's just an option. Yeah. What you are required to do is the notice to cease for those four reasons, that we discussed that require
Right,
a
I got
notice to
that.
cease. The notice to cease, and then the termination notice, and then if it goes that far, then through the court.
Hmm.
So those are kind
Okay,
of the main
thank you.
three things. Yeah.
All right, sounds good. Thank you.
Yeah. And definitely if you have a specific scenario, feel free to come talk to us and get kind of more into the nitty-gritty of it all.
I will be definitely there. Don't you worry.
Oh,
I will
perfect.
be
Yeah.
there. Thank you.
Great. Thank you. All right. Anybody else? Okie dokie. I don't see anybody else. So feel free, again, to come to see us, or if you want to send us an email, you can do that. But I really appreciate you taking the time to come to the workshop today. And we will be following up again by email with the PowerPoint hard copy of this and a link to the survey. So have a great day. And I guess happy Thanksgiving already. All right. Bye bye.